Discussion of our trademarks and brand protection that's being presented to us by Judith Keene today. It was a very interesting discussion last week, 2 weeks ago, last session. And I think that we're diving a little bit deeper in the trademarks this week. So I'm looking forward to that. For those of you that are new to the Business Recovery Initiative webinars, we do have a lengthy series on our website. I think we have about 10 or 12 now, covering all topics from financial issues to PPP, forgiveness to trademarks, and a lot of different legal issues for employee-employer relations. So I do recommend that if you're facing some challenging times right now and would like to just some additional information, all of these webinars are free. And they are on our SBDC website, which is at Grand Junction, sbdc.org/recovery. But let's go ahead and get started today with the second part of our trademark discussion with Judith Keene. Judith, welcome.
Good morning. Thank you. So today, as Laura mentioned, we'll be expanding on what we started talking about 2 weeks ago. A couple weeks ago, we talked about how to pick a protectable trademark and a protectable brand. And today we'll be talking a little bit about actually protecting that brand. People sometimes think that once you pick a trademark, that's all you need to do. Unfortunately, your improper use or others' misuse of your trademark can cause you to lose your rights to it. Last time we talked a little bit about genericide and how some trademarks can lose protection through use as a noun. Aspirin, escalator, and cellophane all suffered those fates. So let's just launch in. We've only got a half an hour, so there's a lot to cover. So you've completed your trademark search that we talked about last time, and you've talked with legal counsel, hopefully, to make sure that your trademark is truly available for your use. Now you are going to use it as an adjective whenever you use it, and not a noun. If your trademark and your company name happen to be the same, remember when you're talking about your company name, it's a noun. When you're talking about your trademark, your brand, it's an adjective. You'll be putting a TM or an SM on the right-hand shoulder of the trademark so that you alert everybody that you claim this as your own. And I put a few examples on this slide so you can see them. And you can protect your trademark as soon as you begin using it at common law. Most people think, oh, I've got to get it registered. I have no protection without registration. Well, under the law in the United States, you have protection at common law without registration. But registration does give you some benefits, and they are not insignificant. If you're planning on using your trademark only in one state, in other words, you're only going to sell in Colorado, you won't have customers from out of state purchasing your product or your services. You'll only want to register in Colorado. That would be with the Colorado Secretary of State. It's a fairly inexpensive process, but you cannot file that application until you begin to use the mark. You have to actually sell to customers before you can make that move. The application process is controlled by statute, and there's an online form. Registration, once gained, is not evidence of a valid trademark. The reason I say that is the Secretary of State will register anything as long as it is one character different than the other registrations that it already has. That being said, that's not the legal standard for what if one trademark is too similar to another. So state registration does put people on notice that you claim your mark. It's a place people look when they're searching to determine if they can use a trademark. So it is beneficial to file there if you are only using your mark in one state. Your registration in Colorado is valid for 5 years, and you can renew it 6 months prior to the expiration. I think the renewal fee at this point is $10, so this is a very inexpensive process. But remember, you must search for the trademark before you file because the Secretary of State will not. I cannot tell you the number of times I've been in pre-litigation with someone who said, but the Secretary of State let me have it. It must be okay. And it was not. So make sure to check before you file. Inexpensive process. Filing fees do change. So these fees are valid now. They may not be valid in a year. When would you file federally? So you can file at a national trademark office in countries throughout the world. Almost every country has their own intellectual property registration procedure. The US procedure is used when you are using a trademark on products and services that affect interstate commerce. The reason I say affect interstate commerce is that you don't always have to travel between states with your products and services to affect interstate commerce. Let's say you own a restaurant. Well, you can't pick up your restaurant and move it to another state if you only have one location, but you do serve customers from other states. So as soon as you have customers from out of state buying those services, you've affected interstate commerce. Advertising is not use. Selling a product, providing a service is use of a mark. Federal registration is not granted until use begins. Like state law, federal registration is controlled by statute. Registration is through the U.S. Patent and Trademark Office, which is one of the only self-supporting federal government agencies. It does not need much in the way of funding because it charges applicants for all the applications. When you file an application, it may be for the principal register. You never file an application for the supplemental register, but if you have a very descriptive mark, you will either be denied registration or relegated to the supplemental register. Pros and cons to that goes down a deep rabbit hole to talk about it, but suffice it to say that registration on the supplemental register is evidence that you don't have a valid trademark. However, you still get to use an R in a circle, and the trademark office can still deny junior applications that are confusingly similar to your mark. So that's still a great place to be. A federal registration is a 10-year term as opposed to the state, which is a 5-year term. And the federal registration process is administratively and legally reviewed. So an attorney at the PTO reviews your mark to see if it's likely to be confusing with a already registered trademark or an application. Some advantages: after 5 years, you get to file an affidavit of incontestability, and that is just what it sounds like. It's very difficult for third parties to contest your registration after that period of time. And in the US and in many countries around the world, you can file an intent to use trademark application, which means you're not actually using it yet. Registration won't be granted until use begins, but your filing gives some great benefits. What are the advantages? Well, if you have a common law registration and somebody infringes your trademark, you can absolutely go after them and sue them and say, hey, we have prior rights. We're senior to you. You got to stop. But if you have registration, you jump through a few less hoops in that process. Your registration is prima facie proof, and all that means is it's evidence of your exclusive right to that mark and that it's not confusingly similar to any other registered or pending trademark applications. The reason that's important is it puts the burden on the infringer to then prove that either your mark's invalid or their mark's not confusing to you. With registration, you may be able to get statutory damages, especially if there is a counterfeit trademark involved. You can use an R in a circle. You cannot do that with a common law mark. And examiners, in reviewing subsequently filed applications, can deny junior applications if they're too similar to yours. As I said before, you get to file that incontestability affidavit. And if you haven't begun use of your mark, that intent to use application puts others on constructive notice of your rights. So if you file an application, but you don't use your mark for, let's say, 2 years, someone who begins using a confusingly similar mark during that 2-year period is still junior to you, and you can still stop their use. Now, no odd little detail, if there's a foreign application that's based on a foreign registration in a country with whom we have a treaty, and their application is filed before yours, they take seniority because they have a pre-existing application in another country, and we look at the data they're filing in their country. So once you file that application, what happens to it? I get this all the time, and I actually have an entire blog post devoted to this process so people can follow it along. You file your application, whether it's intent to use or a use-based application. It's 3 to 4 months before an examiner is even assigned to that application. So it's kind of a dead time. There may be some administrative documents that you get in between a notice of design code description or a notice of pseudomark. They're not substantive documents, and all those do is allow people to more easily search for your trademark and find it at the PTO database. For example, if you use a word and spell it differently than the common spelling, you'll get a notice of pseudomark with the common spelling so that people could locate your unusual spelling. Now, once the examiner has the application, they review it and determine if there are any issues. If they're minor, there may be a telephone call, an examiner's amendment. If it's more major, then you'll get an office action. If that happens, talk with an attorney because we often write briefs in response to those. If there are no issues during the examination process, you'll get a notice of publication and an email, which we call a notice of publication. It's a little duplicative, but it's just the way the office works. And that means that you've been approved for examination, and they're going to publish your mark so that outside parties can either file a letter of protest or they can oppose your application. That publication happens in an official gazette that's published by the USPTO, and it's a 30-day period. If no one opposes your mark during that period and you begin using your mark, usually registration is within 1 to 3 months after that publication period. If you haven't begun using your trademark, you get something called a notice of allowance. This just means that everything is done and you now only have to prove use in interstate commerce. You have 36 months to do that. Every 6 months during that period, they want a little money. So you file an extension of time before that 36 months is over, and at any time during that period, you can file your statement of use. Once that is examined and accepted, you get a registration. Now, during that period of time, there can be errors at the office. There might be errors in an application, and there's something called a Section 7 petition that you can file to correct those errors. If it's the Patent and Trademark Office fault, there's no filing fee. If it's your fault, there's a small filing fee. Now, during that period of time, only time that third parties can contest and oppose your mark is during that opposition period. There's something called a letter of protest that can also happen. It's a fairly new process. It is gumming up the works. It is filed directly with the commissioner, not with the examiner, and the commissioner can make a decision without discussion with the examiner to cancel your application, cancel a registration, which has happened. And it's a process that is probably going to start getting reviewed because there is a lot of concern between the examiners and the commissioner's office is how that's going to work, because it's a work around the examination process that's causing some problems. After registration, the third parties may petition to cancel your registration up to 5 years. Again, the affidavit of incontestability stops that cancellation process. To maintain your registration, there are maintenance documents that need to be filed between the 5th and 6th year after registration, and thereafter every 10 years after registration. There's small fees associated with it. One of the things I always tell people, if you're thinking your trademark is only a 6-month to a year life, don't federally register it. You're wasting your money. This is for long-term marks that are going to be around for at least 5 years. Now, footnote to that, if you think you've got something that is so valuable, even if it's a short run, you might consider registration, because there might be licensing opportunities down the road. I earlier mentioned that it's not only the US that has this federal registration procedure. Countries around the world have the same procedure, and there's no one application for every country. The EU has a unified European Intellectual Property Office for the entire European community, but every other country has their own process. You can hire an attorney in each country to file an application. Only an attorney who is licensed to practice in that country can file that application. However, there is a process through a treaty where you can file in about 123 countries through the USPTO. It's about half the price of filing nationally, but there's some pros and cons to it. The cost considerations are important to consider, but oddly, the Madrid Protocol, which is the treaty that I'm talking about, requires these foreign applications to be dependent on your US application. So if for some reason your US application fails, is opposed, goes abandoned during the application period or the first 5 years of registration, all of those treaty filed international registrations will fail. They will also be canceled. So if you're selling still overseas, but you're not selling in the US, filing nationally might be the better approach. It's very important to have a plan. When are you planning to sell in these other countries? What is the process you're going to be thinking about? Most of these foreign countries do allow intent to use applications, but if you don't begin use of your mark within 2 years of registration, you'd be subject to cancellation. Common law rights don't exist in every country, so you'll need to check all the countries in which you're interested in protecting your mark before filing. For example, the Philippines, you don't file, you don't have a trademark. Make sure that you search in each country for availability of your trademark. Just because it was available in the United States doesn't mean it's available overseas. There are plenty of search engines for foreign intellectual property offices. It's helpful if you speak the language. And there are also outside search studies that can be ordered that we rely on when we're filing in foreign countries. Remember when I talked about earlier that in the US, certain foreign applications might have priority over you? Well, the same is true if you file in a foreign country under these treaties. If you file within 6 months of filing your US application, you'll gain the priority date of your US application filing, which gives you a significant advantage. And again, that's up to 6 months after the filing. Maintaining your rights. You've got either common law or federal registration or state registration. You can't sit back and think that's going to be enough. You still have to make an effort to protect your trademark. Your rights can be lost if you don't use it as an adjective, especially if it's a more descriptive term. If others use it without your permission, and this doesn't matter whether it's registered or not. The legal standard for determining whether you have a right to stop others from using your mark is called the likelihood of confusion. Actual confusion is not important. I've set out the factors here. Do the marks look alike? Are they pronounced similarly? Are they translated similarly? Do they suggest something similar? What was the intent of the user in adopting the mark? Was it to counterfeit your product? What's the similarity in use, the manner of marketing, trade channels, and consumers? What's the sophistication of those consumers? Is this an impulse purchase, or do people research it before they buy it? How expensive is it? And what is the degree of care consumers are exercising? Always consult with legal counsel. This is not something you can determine easily unless they're two identical marks with two identical products. In some circumstances, people have a right to use your trademark. It's called fair use. This is a funny example. It's a parody example. If you can see this, it's the Louis Vuitton trademarked fabric purse design that has been placed on a canvas bag, and on the reverse side of it, it says "my other bag." And this went up and down. Should we sue? Should we not sue at Louis Vuitton? And Louis Vuitton took it as a compliment and laughed about it. And no one would ever be confused that this is a Louis Vuitton bag. And that's the real key there. What is the likelihood of confusion, right? Another fair use is nominative use. You'll often see products comparing one product to another product. And as long as they use the least amount of that trademark as possible, it's fine to do. And I say that with talk to legal counsel before you do this, because if you use the actual trademark logo of a competitor, that's going too far. There's a very fine line between what's okay and what's not. An example of a parody gone wrong was an anti-nuclear group who used Mutant of Omaha on their t-shirts. And Mutual of Omaha did not take kindly to this. They sued and ran a survey to see if customers were confused as to the source and affiliation. And what they found was that people thought Mutual of Omaha supported this group. And because of that confusion of affiliation, Mutual of Omaha won. Group had to come up with another phrase. So there are other protections that are available for your brand and your products. One is patents. Now this is a little bit silly, but patents are novel and useful inventions. Useful is pretty easy to get past. And I show that with this funny example. This is from the 1882. This was a patent that was granted for a device for waking people from their sleep. And if you see, there's a clock and a pulley and something that when the clock rings, the device falls on the sleeper's face. And they recommend cork or some other light material for those pieces, but that sufficed for the useful element. I don't think it ever sold. The novelty requirement's a little harder. It has to be something that is non-obvious, that is new and different, and not easily seen from what's already in existence. That's a whole other topic, but important to think about when you're thinking about protecting your products, your brand, and your services, because some methodologies might indeed be patentable. Additional brand protections are copyright, which protects artistic designs reduced to a tangible medium of expression. All that means is you have to actually take the idea and the art and affix it to something. If I give a speech that isn't written down, it's not protected. If I write it down, it becomes protected. Different countries have different laws. So if you're going to another country with your products, it's good to check out their copyright law too. Trade secrets, something that is confidential and you take efforts to keep it secret, like the Coca-Cola formula locked up in a vault. The minute you stop taking those efforts, it stops being a trade secret. Contracts. This is the all-encompassing requirement. If you have a brand, you want to make sure your employees, independent contractors, vendors, customers, everyone with whom you do business knows what they can and cannot do with your trademark. You make rules, you allow for inspection, and you require changes if there's any problems. And if you allow any third party to make use of your trademark, make sure you have a licensing agreement in place. There's specific requirements to that license to make sure you don't accidentally give up your rights. And that is really all I have for protecting the trademark once you come up with it. And just so everybody is ready for the next session, in 2 weeks, we'll be getting a much deeper dive into copyrights and how those copyrights can not only protect your brand, but things around your brand, your advertising, your website, your written materials, your workshop materials, anything that you create that's artistic, that's original, that you want to keep for yourself and or license to others. Laura, any questions?
Thank you, Judith. No, that I'm looking forward to that copyrights one. So I did have one, actually, I had quite a few questions. You answered them as we went. But the one question that I wanted to, I think it's obvious, but I just kind of want to loop back around. So we've talked about state, federal, and then of course, international. Do you need to do each of those? So for example, if you file for federal trademark, does that cover the state?
Yeah.
Or you
And
need to
that's
do
a
state and
great
then
point.
federal?
That's a great point that I really didn't go over. If you have federal registration, you do not need to maintain state registration on top of it. There are a few people who do file state registration prior to filing federal, just in case they don't get their federal, and to hedge their bets if it's an intent to use and they haven't begun use elsewhere. I have some folks who say, oh, I just don't want to deal with the federal. I'm only using in Colorado and Wyoming. I'll just file in those two
And
states.
those both of those
But it
states, that
is
makes sense.
interstate commerce between those two states, so you could file federally.
And then assumed, obviously, if you want to do international, you still want to do a United States federal, as you mentioned. If you do that, and then within the next 6 months, you're filing internationally, it can go back to that federal date. So you would want to make sure that you do your US federal filing no matter what.
Right, and you can't take advantage of the treaty without a federal filing.
Without a federal one, okay.
Right, but let's say you're planning on selling in the UK and not selling in the US. Well, then you'd file in the UK and not here. Now, I want to add a little footnote because I said UK on purpose. Brexit is happening, and until December 31st, any application filed in the EU will also include the UK. As of December 31st, any registration will be moved to the UK. And by January 31st, we should get notice of the new registration and numbers in the UK. And then you'll just have the maintenance every 10 years in the UK in addition to the EU filing. If it's an application that has not yet registered, that application will get moved to the UK and begin examination in the UK.
Okay. Well, thank you.
Yeah.
Judith, you mentioned your blog. Is that something that you'd like to share?
Yeah, it's denverintellectualproperty.blogspot.com.
Okay. I bet there's a lot of information for people that are looking to go explore this a little bit further on your blog. So
Yeah.
we'll put that out there. Well,
Wonderful.
thank you so much. That was as always, very informative. And I love how you're giving us just little bites of this, because it's all something that we can digest and understand, and it's not too big. Speaking for myself, but I think for other people as well. So I look forward to our next one in 2 weeks. It sounds like copyrights and some other brand protection things. So thank you so much again, Judith, and we'll see you in a few weeks.
Absolutely. Thank you for having me. And remember, nothing should be considered legal advice. If you have a specific issue, please speak with your counselor.
Thank you.
All right. Take care.
Bye-bye.